Carson. Essentially says that the main program let's get the world state outline.
Just part of the instructions.
Has no institutionalized education. Provides its we're going to get started. Well, it's never.
Good evening, everyone. Thank you for joining us. Deacon Mike Kelly, representing Monroeville Interfaith Ministerium here at the Monroeville Library. And with us today is Professor Wilson Huhn. Wilson Huhn grew up in Chautauqua County, New York, where he attended Chautauqua Central School. In those days, his family spent their summers at Chautauqua Institution, and for many years, his parents managed a hotel near the amphitheater for nonprofit organization that brought foreign students to the grounds for the summer. Will taught special education in Connecticut, high school in Texas, worked as an attorney and judicial law clerk in Cleveland, Ohio, and taught constitutional law at the University of Akron Law School for over 30 years, where he retired in 2015 at the rank of distinguished professor. He is currently professor at Duquesne Law School. He has won many awards for teaching and scholarship. He has published many law review articles and books. He's the author of the popular book, The 5 Types of Legal Arguments. So the format this evening will be that will present his information first, and then we'll have opportunity for discussion and questions. The people in the room, particularly, I ask you to speak up if you have questions, because we have just the one microphone. Wilson Huhn.
Good evening, everybody. Thank you so much for inviting me. It's quite an honor to speak to you, and I'm so very grateful for this opportunity. I'm going to go ahead and share my screen that has the PowerPoint presentation that I'll use to accompany my presentation. It's entitled "The Role of Religion in America, Salvation or Supremacy." Religion plays a critically important role in America, but America is not a Christian nation. It is a nation with over 100 recognized religions. More importantly, it's a country that protects every individual's right to freedom of religion. Christian nationalism is the belief that identifies being an American with being a Christian. It is the notion that a true American, an authentic American, is a Christian. Those who believe this are wrong. Devout Jews, devoted Muslims, dedicated atheists, as well as those who have no particular religious belief, are no less American than a Christian. Our ancestors came here from many parts of the world, some willingly seeking a better life, some fleeing war, starvation, or religious persecution, and some in chains. But all of us are equal and are equally possessed of certain inalienable rights. Our most cherished rights are set forth in the Bill of Rights, and the first words of the Bill of Rights are these: Congress shall make no law respecting an establishment of religion. Notice the precise wording of the Establishment Clause. It does not prohibit the establishment of a religion. It prohibits the establishment of religion. Notice also the word respecting. Not only is Congress prohibited from establishing religion, but it may also not make any law respecting an establishment of religion. That is, Congress may not enact any laws involving or having anything to do with an establishment of religion. The second provision of the Bill of Rights is this: Congress shall make no law prohibiting the free exercise of religion. Under the Free Exercise Clause, there can be no laws in our country regulating religious belief or religious doctrine. Americans are free to believe whatever they want to believe. And while it's sometimes necessary to regulate religiously motivated conduct, those regulations are constitutional only where it's necessary to prevent harm to other people. Given the first two phrases of the First Amendment, how could any American possibly believe in Christian nationalism? The core of Christian nationalism, like every other type of bigotry, is based upon a feeling of superiority. Most people want to think well of themselves. There's many ways that we might accomplish this: by doing a good job at work, by volunteering and helping others, by being a loving parent or a good friend or a loyal citizen. But some people want to feel good about themselves, not because of anything that they have done, but because of their status in society, by being wealthy, by living in a posh neighborhood, by having gone to the right schools. And then there are those who are proud because they're white, because they're male, or because they are straight. It's no different with religion. Some people belong to a particular religion to become a better person. Other people believe that they are better than other people because they belong to a particular religion. Just as with other forms of bigotry, it's a short step from believing that they are superior to believing that they have the right to rule over other people. We must always ask ourselves, am I using religion to discover the rules that I want to live by? Or am I using religion in order to dictate to other people how they must live? During the colonial period, Americans invented the principle of separation of church and state, and we placed it first in the Constitution. Let's examine the role of religion in America from the earliest days of European settlement, either as a means of salvation or as a mark of supremacy. Our ancestors came to these shores in part to escape the religious wars in Europe. Presbyterians from Scotland and Northern Ireland, Lutherans from the Rhineland, and Catholics and Jews from wherever they faced discrimination and oppression. Why was the Establishment Clause so important to the framers to be listed first among the Bill of Rights? It was because of the colonial experience with laws tending to establish religion. The Establishment Clause is historically identified with the concept that there must be a separation of church and state. That phrase was coined by the colonial leader Roger Williams, who in 1635 was exiled from the Massachusetts Bay Colony for heresy. In 1644, in protest of the Massachusetts laws regarding church attendance at the established church and outlawing the expression of beliefs that deviate from the expected norm, Williams wrote, "When they have opened up a gap in the hedge or wall of separation between the garden of the church and the wilderness of the world, God hath ever broke down the wall itself and made his garden a wilderness, as it is in this day." Williams also wrote that the civil government is based upon the will of the people, not religious authority. The colony of Massachusetts continued to punish dissenters, exiling Anne Hutchinson and culminating with the execution of Mary Dyer and other Quakers. But freedom of religion blossomed in Rhode Island under the leadership and example of Roger Williams. A century later, in 1786, the year before the Constitutional Convention, James Madison and Thomas Jefferson opposed a tax that the state of Virginia had adopted to support ministers. Madison wrote his famous Memorial and Remonstrance against religious assessments. Madison stated, "We hold it for a fundamental and undeniable truth that religion, or the duty which we owe to our Creator and the manner of discharging it, can be directed only by reason and conviction, not by force or violence. The religion then of every man must be left to the conviction and conscience of every man, and it is the right of every man to exercise it as these may dictate." Madison also led the fight to enact Jefferson's Bill for Religious Liberty, making it unlawful to use tax dollars to support religious establishments. The bill began with these words: "Almighty God hath created the mind free. All attempts to influence it by temporal punishments or burdens are a departure from the plan of the holy author of our religion. No man can be compelled to frequent or support any religious worship or ministry, or shall otherwise suffer on account of his religious opinions or belief, but all men shall be free to profess and by argument to maintain their opinions in matters of religion." Our first president, George Washington, reassured both Catholics and Jews that in this country, they would be free to practice their religion without interference from the government. In 1790, in his letter to the Truro Synagogue, the new president wrote, "Everyone shall sit in safety under his own vine and fig tree, and there shall be none to make him afraid. For happily the government of the United States gives to bigotry no sanction, to persecution no assistance, requires only that they who live under its protection should demean themselves as good citizens." In 1791, the Bill of Rights was adopted, whose first provision we have seen was the Establishment Clause. In 1802, our third president, Thomas Jefferson, wrote to the Danbury Baptist Association and described the Establishment Clause and the Free Exercise Clause in these terms: "I contemplate with sovereign reverence that act of the whole American people, which declared that their legislature should make no law respecting an establishment of religion or prohibiting the free exercise thereof, thus building a wall of separation between church and state." The battle over slavery and Abraham Lincoln's use of religious imagery. John Adams, Benjamin Franklin, and Alexander Hamilton all opposed slavery. But the anti-slavery movement was grounded in religion. In 1845, the Reverend Theodore Parker authored the book, A Letter to the People of the United States Touching the Matter of Slavery. He and other transcendentalists and many other religious leaders were prominent abolitionists. But slavery was also defended on the ground of religion. Here is Richard Philemon in 1822. "The right of holding slaves is clearly established by the Holy Scriptures, both by precept and example. In proving this subject justifiable by scriptural authority, its morality is also proved, for the divine law never sanctions immoral actions." And Richard Fuller in 1845, "What God sanctioned in the Old Testament and permitted in the New cannot be sin." Because of slavery, the Protestant churches of the South seceded from their northern brethren years before the Civil War. In 1844, the Methodist Church adopted a plan of separation. In 1845, the Southern Baptist Convention split from the Baptist Church. And in 1857 and 1861, the Presbyterian Church split into northern and southern branches. Into this maelstrom of schism strode Abraham Lincoln. Lincoln did not define America as a Christian nation, but he used the language of religion and led us to become better people. Lincoln issued the Emancipation Proclamation on January 1, 1863. The response of the South was to identify slavery with Christianity. Here's an editorial in the Southwest Baptist a month after the Emancipation Proclamation, February 19, 1863. If slavery be not of God, then we are fighting against him, and our cause will fail. If it be of God, then our enemies are fighting against him, and we for him in truth. And if God be for us, who can be against us? Christianity lived and triumphed because it was of God, and so slavery in the South with it will live and triumph because it is of God. In addition to freeing the slaves and saving the Union, Lincoln created a new way of speaking and writing. His style was greatly influenced by religion. His mother, Nancy Hanks, had memorized the Bible and taught it to her son. As a young boy, after church, he would stand on a stump and repeat the sermon for the other children. Lincoln's boyhood church, the South Forks Church, had itself split over the slavery question. His family joined the anti-slavery congregation. President Lincoln often read the Bible and told a confidant that when he did, he heard his mother's voice. Compared to the verbose and flowery prose of orators like Daniel Webster and Edward Everett, Lincoln's style was straightforward and plain spoken, as you would expect from a man with no formal education. But Lincoln's letters and speeches were also infused with subtle and complex biblical imagery, the language of the Bible. Here are a few memorable passages from his work. Here's a passage from one of the debates with Stephen Douglas in Lewiston, Illinois, on August 17, 1858. Notice the transition from landscape imagery to biblical imagery midway through. Now, my countrymen, if you have been taught doctrines conflicting with the great landmarks of the Declaration of Independence, if you have listened to suggestions which would take away from its grandeur and mutilate the fair symmetry of its proportions, if you have been inclined to believe that all men are not created equal in those inalienable rights enumerated by our Chart of Liberty, let me entreat you to come back. Return to the fountain whose waters spring close by the blood of the Revolution. Think nothing of me. Take no thought for the political fate of any man whomsoever, but come back to the truths that are in the Declaration of Independence. You may do anything with me you choose, if you will but heed these sacred principles. You may not only defeat me for the Senate, but you may take me and put me to death. While pretending no indifference to earthly honors, I do claim to be actuated in this contest by something higher than an anxiety for office. I charge you to drop every paltry and insignificant thought for any man's success. It is nothing. I am nothing. Judge Douglas is nothing. But do not destroy that immortal emblem of humanity, the Declaration of American Independence. Members of the clergy all across the country were fascinated by Lincoln's emerging style, his use of cadence, allegory, alliteration, anaphora, and biblical imagery. After his speech in New York at Cooper Union in 1860, Lincoln was invited to speak all across New England, where his words were carefully examined by local pastors and ministers. At a time of great division, Lincoln used the language of the Bible in an attempt to unify us. He expressed our most fundamental values, the ideals that all Americans strive to uphold and to live by with religious imagery. As he stated at the close of his first inaugural, the mystic cords of memory, stretching from every battlefield and patriot grave to every living heart and hearthstone all over this broad land, will yet swell the chorus of the Union when again touched, as surely they will be, by the better angels of our nature. Here's one more example, the Gettysburg Address. As we know, in the opening sentence, Lincoln said, 77 years ago, our fathers brought forth on this continent a new nation, conceived in liberty and dedicated to the proposition that all men are created equal. Why is this language and that which follows so powerful, so meaningful to Americans? Why do we memorize it as children and repeat it so often? The first 6 words of the Gettysburg Address, 77 years ago, Recall the patriarchs of the Bible, including Abraham, Moses, and Caleb. We're reminded of the birth of Ishmael to Abraham in the book of Genesis, to the vibrant health of Caleb, as well as his willingness to go to war in the book of Joshua, and to the images of weakness and death in old age from the book of Psalms. The next four words, our fathers brought forth, extend the analogy. Our fathers, the founders and the framers, brought forth a new nation. The words brought forth are used only twice in the King James Bible, evoking birth imagery and liberation imagery. At 2 Chronicles chapter 6, verse 5, the Lord states, I brought forth my people out of the land of Egypt. The other Bible passage that Lincoln's listeners would have been reminded of is from Matthew chapter 1, verses 24 to 25, describing the birth of Jesus. Then Joseph, being raised from sleep, did as the angel of the Lord had bidden him, and took unto him his wife, and knew her not till she had brought forth her firstborn son, and he called his name Jesus. What did the founders and the framers give birth to? They wrote the Declaration, which is implicitly identified with the 10 Commandments in the Bible. The birth of our nation is also implicitly equated with the birth of Jesus. Later, in this 11-sentence speech, Lincoln dedicated Gettysburg to the brave men, living and dead, who struggled there. And he told us that it was for us, the living, to dedicate ourselves to the great task before us, that this nation under God shall have a new birth of freedom, and that government of the people, by the people, and for the people shall not perish from the earth. That phrase, government of the people, by the people, and for the people, was originally coined by John Wycliffe 5 centuries earlier to explain why he had translated the Bible into English. The theme that runs throughout the Gettysburg Address is that of birth, life, death, and rebirth. All of this was subliminally conveyed using the language of the Bible. We're not a Christian nation, but we are deeply moved by the language of what Christians call the Old Testament and the New Testament. Christian nationalism in the United States has long been identified with white supremacy. Just as some people used religion to justify slavery before the Civil War, since the Civil War, others have used it to justify racial discrimination. In June of 1958, Mildred Jeter, a Black woman, and Richard Loving, a white man, residents of Virginia, were married in the District of Columbia. When they returned home, they were arrested for violating the laws of Virginia that prohibited interracial. In imposing a prison sentence of 1 year, the trial judge stated, Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with his arrangement, there would be no cause for such marriage. The fact that he separated the races shows that he did not intend for the races to mix. In Loving versus Virginia, the Supreme Court reversed the rulings of the Virginia courts and for the first time finally declared that laws against interracial marriage are unconstitutional. The court ruled that such laws violate both equal protection and the right to privacy. The year was 1967. The Supreme Court's interpretation of the Establishment Clause and the Free Exercise Clause. How has the Supreme Court interpreted the Establishment Clause and the Free Exercise Clause? I will start with a historical examination of the relevant Supreme Court cases and bring you up to date. The first time that the Supreme Court struck down a law in protection of freedom of religion was 1940 in Cantwell versus Connecticut. 7 years later, in Everson versus Board of Education, after reviewing the words and actions of Madison and Jefferson in colonial Virginia, the Supreme Court issued this description of the meaning of the religion clauses. The establishment of religion clause of the First Amendment means at least this: neither a state nor the federal government can set up a church. Neither can pass laws which aid one religion, aid all religions, or prefer one religion over the other. Neither can force nor influence a person to go or to remain away from church against his will, or force him to profess a belief or disbelief in any religion. No person can be punished for entertaining or professing religious beliefs or disbeliefs, for church attendance or non-attendance. No tax in any amount, large or small, can be levied to support any religious activities or institutions, whatever they may be called, or whatever form they may adopt to teach or practice religion. Neither a state nor the federal government can openly or secretly participate in the affairs of any religious organizations or groups, and vice versa. In the words of Jefferson, the clause against establishment of religion by law was intended to erect a wall of separation between church and state. For 75 years, the Supreme Court consistently and repeatedly adhered to the bedrock principle that freedom of religion requires the government to remain neutral with respect to religion. By word and by deed, the government may neither promote nor inhibit religion. In 1962, in Engel versus Vitale, the Supreme Court ruled that it was unconstitutional for the New York State Board of Regents to compose a prayer to be read to public school students. And in 1963, in School District of Abington Township versus Schempp, the court struck down a Pennsylvania law that required 10 Bible verses to be read to public school students every day. In Schempp, the court stated, "The wholesome neutrality of which this court's cases speak thus stems from a recognition of the teachings of history that powerful sects or groups might bring about a fusion of governmental and religious functions, or a concert or dependency of one upon the other, to the end that official support of the state or federal government would be placed behind the tenets of one or all orthodoxies. This the Establishment Clause prohibits." And a further reason for neutrality is found in the Free Exercise Clause, which recognizes the value of religious training, teaching, and observance, and more particularly, the right of every person to freely choose his own course with reference thereto, free of any compulsion from the state. This the Free Exercise Clause guarantees. The court explained that any law must have a secular purpose and a primary secular effect. The test may be stated as follows. What are the purpose and the primary effect of the enactment? If either is the advancement or inhibition of religion, then the enactment exceeds the scope of legislative power as circumscribed by the Constitution. That is to say, that to withstand the strictures of the Establishment Clause, there must be a secular legislative purpose and a primary effect that neither advances nor inhibits religion. This came to be called the Lemon Test because the court issued it in the 1971 case of Lemon versus Kurtzman. In Lemon and many other cases involving funding of religious schools, the Supreme Court distinguished between state funding for educational materials, such as maps and globes, which was permissible, and funding for teacher salaries, which was not permissible. In 2014, however, the Supreme Court overruled the Lemon Test and substituted for it a tradition test. In Town of Greece versus Galloway, the court upheld the practice of a town board to hold sectarian prayer at the beginning of town meetings because it is traditional. In two religion cases handed down this year, the court did not mention the principle of separation of church and state or the requirement that the government must remain neutral with respect to religion. These ideals, long understood to be central to freedom of religion in America, have been abandoned by the court. The right to privacy. Starting in 1942, in over a dozen major cases, the Supreme Court struck down laws restricting people's rights to make decisions concerning sex, contraception, marriage, childbearing, parenting, living arrangements, and medical decision-making under the principle of the right to privacy. In defining this right, the Supreme Court said, these matters involving the most intimate and personal choices a person may make in a lifetime, choices central to personal dignity and autonomy, are central to the liberty protected by the 14th Amendment. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state. The most famous of these cases is Roe versus Wade, which in 1973 recognized the right of a woman to terminate a pregnancy in its early stages. In 2003, the Supreme Court struck down laws that made same-sex intercourse a crime. And in 2013 and 2015, the court declared that gay and lesbian couples have a constitutional right to marry. Earlier this year, in Dobbs versus Jackson Women's Health Organization, the court overruled Roe and held that a woman's right to choose is not protected by the Constitution. The court redefined the right to privacy as including only those rights that have been traditionally recognized in America. And the court found that the right to choose to have an abortion was traditionally not recognized. The Supreme Court has done the same thing to the right to privacy that it did to freedom of religion. The court abandoned a standard that evaluates the constitutionality of a law by the actual effect of that law on people's lives, and has reduced our constitutional rights in this arena to a tradition standard. The right to vote. The right to vote is the hallmark of a citizen. One person, one vote is based upon the principle that we are all created equal. No person, no family, no race, no religion, no caste, no political party has an inherent right to rule over us. All just powers of government are derived from the consent of the governed, and in granting that consent, every person is the equal of every other person. A new study shows that Christian nationalists wish to make it more difficult and more expensive to vote. They oppose automatic voter registration. They oppose voting by mail. They oppose expanded time for voting. Christian nationalists support gerrymandering, which dilutes the votes of their opponent. They support laws making it difficult to vote and to register to vote. They also support the independent state legislature doctrine, which would give state legislatures the right to gerrymander congressional districts and appoint presidential electors independently of state laws, state courts, state constitutions, and state elections. The Supreme Court has agreed to hear a case, Moore versus Harper, which will in effect decide whether state legislatures can reject the vote of the people for President of the United States. In conclusion, one of the principal building blocks of America is the principle of separation of church and state. In America, no judge or lawyer can cite religious authority for any legal principle. The Bible is not law, nor does any religious body have the legal authority to say how people have to live their lives. Religion is freely chosen in America, and there is a long and proud tradition of Americans using religion to examine how we choose to live our own lives, of seeking personal salvation. But no single religion defines America or represents what it is to be an American. No religion is sovereign in America. The United States of America was conceived in liberty and dedicated to the proposition that all persons are created equal. We are all endowed with certain inalienable rights, and among those rights is freedom of religion. Thank you very much.
Thank you, Will.
Great.
Okay. We have some questions here.
Sir, speak up. Stand up. a quick comment and then a question. You talk about Lincoln and the Gettysburg Address. I would just quickly say that people should also pay attention to the second inaugural, which would be my vote for the greatest speech in human history, because there Lincoln sees the Civil War in explicitly spiritual terms, sees slavery as a great national sin, and sees the bloodletting of the Civil War as justifiable punishment for that sin. So if you folks haven't read the second inaugural lately, I would press it upon you. My question is this. Constitutional scholars talk about the conflict between the two religion clauses, the free exercise clause and the establishment clause, and that specifically when the government seeks to separate church and state, it implicates, it seeks to fulfill its duties under the establishment clause. It implicates the free exercise clause because those laws have effect upon people's practice of religion. And in preparation for your talk, I was looking at the recent Supreme Court decisions, and it really seems like the court is now burying the establishment clause under the free exercise clause. And in particular, I today read Carson v. Macon, which mentioned, and although I'm not an alarmist when it comes to Supreme Court decisions, and I'm uncomfortable with people who talk about them in an alarming way, I was appalled by this decision because it effectively says this basically that the state of Maine had a tuition assistance program for rural parents in areas where there was no high school, and had a plan to assist with tuition to send their children to private schools. And the law said that the assistance could only be used for schools providing a secular education. It didn't necessarily exclude church schools. But the court completely seemed to sweep any obligation under the establishment clause aside and said that this is a discrimination against religion. It's a discrimination, and therefore it violates the free exercise clause. Therefore, if it's going, if the state of Maine is going to provide a benefit, an educational benefit, it has no interest whatsoever in limiting that benefit to secular education. It is effective, and in fact has an obligation under the free exercise clause to provide a provision for schools which are explicitly and thoroughly religious in nature. And it seemed to go so far as to say the implication was that the state of Maine has no interest whatsoever in providing secular education. And that strikes me as very disturbing, given the fact that we have Justice Alito gave a speech earlier this year in which he likened the fight against secularism to the fight against communist totalitarianism. I'm wondering where the court might go.
Well, first of all, what is your name so I can respond personally?
Mark Kozlowski.
Mark, hi.
Hi.
On your first point, Mark, relating to the second inaugural, you're absolutely right. The second inaugural is absolutely infused with religious imagery. In fact, there Lincoln does something that, so far as I know, he only did one time before. He actually quotes the Bible. He just almost never quoted the Bible, but you can see he used religious imagery all the time and in very beautiful ways. But in the second inaugural, he quotes the Bible several times. It's fused with biblical imagery. You know, right afterwards, they went back to the White House, and there's this crush of people, and the guards wouldn't let Frederick Douglass in, and he sent word to Lincoln that he was out there, and Lincoln sent word, yeah, let him in. You know, and Douglass, who had met with Lincoln already a couple of times, came in, and Lincoln said, you know, Douglass, what do you think of it? I value your opinion more than any other. And he said, Mr. President, it was a sacred effort. No, that's just about a month before Lincoln was assassinated. And after he was killed, Mary Lincoln gave Douglass Lincoln's cane. And Douglass said that he treasured that the rest of his life. So I agree with you about the second inaugural. I could have used that. I mean, obviously, it's the best example of using religious imagery. And thank you for bringing it up, Mark. Your other point is about Carson versus Macon. Everybody, I'm talking about that case tomorrow. I've got to deliver a speech. I've been fighting with other law professors about it. So I'm well versed on Carson versus Macon. Mark very accurately described it, both the issue and the holding and the reasoning and the implications. And Mark, it's just as you say, it's very worrisome. What I notice about it is they do to, and I mentioned it in the speech tonight, the Supreme Court does the same thing to freedom of religion that they do to the right to privacy. The justices of the Supreme Court, you know, over the last century, created these standards for all of our rights. And these are standards that, you know, they're not precise. They do involve judgment, and people can reasonably disagree over the abortion question. People can reasonably disagree over a lot of things. In applying a test like the right to privacy that involves personal and intimate decisions that a person makes over the course of their lifetime, dealing with family and raising children and who you're going to love and who you're going to marry and all of that, and that the Supreme Court is going to strike down a law that interferes with those decisions, you know, unless there's a compelling reason, you know, unless there's a compelling reason for that law. And you can argue about whether a woman's right to choose is more important than the life of a fetus, and people do reasonably disagree about that. But I don't think you can reasonably disagree about the fact that in America, that's the kind of thing that is up to the individual. You know, not absolutely, but presumptively. That this involves her body, and this involves decision making about whether to have children, and it's just something where the court has to weigh that against the other moral considerations, you know, the other life that's involved there, and that's a very important and very critical thing. But instead of doing that, what the Supreme Court did in Dobbs' case is it says, we're not going to recognize the right to privacy anymore. We're just going to go with tradition. And, you know, that's not going to work out very well for Black people or for women or for gays and lesbians. You know, that is not, yeah, the implications are very scary for anybody who's been traditionally discriminated against or traditionally, you know, oppressed. What does this mean? If the Supreme Court had used a tradition test in Brown versus Board of Education, well, we all know what the result would have been, you know. So that's what I see as the real problem with what the court is doing, and why the legitimacy of the court is being called into question by an awful lot of people. I'll be doing it. I'll be calling their legitimacy into question at tomorrow's speech. The other thing that the court did in Carson versus Macon, the case that Mark referenced, and in Dobbs really, is that, how to say this nicely, they weren't exactly accurate. You know, they identified the tradition, and then in Carson versus Macon, they said, we're going to use a tradition test. And then they said, there's never really been a tradition in America of not using taxpayer funds to fund religious education. And as Mark said, that's just not true. You know, there's been a very long tradition of not using taxpayer funds for religious education. We all know that, and the Blaine amendments and all of that. So, I mean, you can argue about what a good policy is, but you can't honestly say there wasn't a tradition of this. And with respect to abortion, the tradition was, gee, did women have the right to abort a child before quickening? Alito says no, they never had that right. But the fact of the matter is they did. They absolutely did. Now, it may not have been for a very good reason. People didn't think that the fetus was alive until quickening. And so, you know, up until 18 weeks, it just wasn't considered to be an immoral thing to do. And that changed about the middle of the 19th century when people began to learn more about human reproduction. But nevertheless, Alito was, I guess another nice word is disingenuous when he says there was no tradition there. So yeah, a couple of big problems, going to tradition tests instead of realistic tests, and not being entirely truthful. Those are going to call into question the legitimacy of any court. There are other questions, other comments?
Well, Dave Morris.
Barbara had her hand up first.
Oh, sorry.
Okay, Barbara, go ahead.
David's question is going to be much better than mine. Go ahead, David.
Well, mine's a very practical question, Professor. Going all the way back to Marbury versus Madison, it's been long held that it is, and Chief Justice Marshall, I think, set this up. It's long been held that it is the province of the third branch of government to say what the law is. Given that reality that has shaped our jurisprudence, and given the present composition of the current Supreme Court, what in the world can the average person do if they are opposed to Christian nationalism, want to support religious rights, want to support a host of other rights, including privacy? What can we do at this point?
You know, the Constitution isn't very specific. It isn't very clear. Another point that Marshall mentioned, oh gee, what's that later case dealing with the Commerce Clause? But he said you can't strictly construe the Constitution. It's not a statute. It's not a set of zoning regulations with specific definitions and everything. It's a grand document that sets forth our rights in very general language. And what does equal protection mean? Well, in the 19th century, to people who were racist, it meant separate but equal. Right. You know, and then they didn't make it very equal, but due process. I mean, that it is just not a self-defining term. And so what the Supreme Court did in the 20th century was they developed these realistic tests like the right to privacy and like government neutrality, government must be neutral. And they're very general tests and they involve a lot of balancing. I think, you know how the American people were very proud of having a written constitution, and the dumb old British, they just have an unwritten one. Yeah. I'm not so sure our Constitution is all that written down. As a practical matter, Dave, I think that we have to vote in presidential elections. The American people every 4 years vote on what the meaning of the Constitution is, because we know that our president will be allowed to nominate, and the way the Constitution reads, the Senate shall vote on those nominees. That wasn't done for Merrick Garland. That was a real abuse of the process, as was the rushing of Amy Coney Barrett's nomination through, another abuse. But the way the system is supposed to work, and the way it's always worked before, is that we respect the will of the people to elect a president, and that president nominates the justices, and that's how you and I have a voice in the meaning of the Constitution. And over time, the only thing you can do is to vote in a manner that will express your views on what the fundamental values of Americans are. And they'll vote too. And so long as we're doing it that way and not with violence, then I think that's the most we can hope for.
Thank you.
Thank you.
Barbara?
Thank you. So thank you for presenting and for everyone to be here. So in the liberal Jewish community, I think we're feeling an increasing gap between American values and Jewish values, which is really concerning. And my question is this: I don't believe a case came to the Supreme Court regarding COVID, but had it, it seems like, has it come to the Supreme Court that you cannot
Not
like
yet.
mandate having vaccines in order to do X, Y, or Z? That hasn't gone to the Supreme Court, has it?
Not
I'm-
yet. But get
Yeah,
there.
I'm trying to recall, I actually debated someone on the abortion question, and her organization had also had been in support of abortion laws, but opposed to the vaccine mandate because they said it violated their fundamental rights.
Right.
And that was the first thing that I said when I got up when it was my turn was, how do you, how does your organization justify making this argument? And of course, it's ridiculous. They see themselves, their own bodily integrity, that they've got a constitutional right not to have a little tiny needle that you can hardly feel stuck in you so that you don't kill other people. That's a horrible invasion of their bodily integrity. Whereas forcing a woman to carry a pregnancy for 9 months where it may be a rapist or it may be an older relative that impregnated her, oh no, she doesn't have a constitutional right there. So it is, Barbara, I think it's a lack of empathy. I think that.
Sorry, and
No,
then
no.
right, maybe a nihilism in a sense, but doesn't it get to the underlying problem? And I appreciate this, except that you're too much on the same wavelength as me, so I'm not getting the challenging.
Yeah, I share the same values. So,
but obviously, but the underlying challenge, and forgive me, but Reverend Kelly, this isn't working for me because your daughter's just too cute, and we're all looking at her. No, I'm kidding. No, bring her back. Now I feel guilty. Anyway, so no, sorry about this. So I'm like this in real life too.
That's
So
okay, Barbara. You should see me teaching. I teach online. I teach law online, and I can't pay attention when the kids are there.
No, of course not.
But I love having them there. I love it
course.
when they're in there.
And now look what I did. And it's Yom Kippur's around the corner. That I'm going to have a repenting moment just for you, Reverend Pastor Kelly there. Okay. So my question though, continues, sorry, everyone. Doesn't it go to a concern about an underlying, I don't know, trust of the system? If it seems a little capricious. And I worry about not only the decisions being made, which again, liberal Jews, and I'm not speaking for every liberal Jew, right? But liberal Jews, I think largely are feeling very much where the American values and Jewish values are going in different directions. Some of you are nodding your head. I don't know if you're thinking about Jews or about your own liberal traditions, but that being said, I think the underlying concern has to do with sort of capriciousness and trust. So would you mind addressing that?
Well, when the Supreme Court overrules any number of fundamental building blocks of American constitutional law, yes, it calls the legitimacy of the court into question. When somebody like me, who has taught constitutional law for most of my long life, is ready to vote to expand the Supreme Court by 4 more members, when I'm ready to do that, when I'm ready to do what I have always regarded as something that was improper and unjustified, but I am willing to do that now. And when somebody is dedicated to the Supreme Court, as I am, is ready to take steps like that, then yes, I think we can say that my faith in the court has been destroyed. one thing I've done in my career, and it's been just a wonderful thing. I've gotten to debate many, many, many people. I've always been willing to go into a debate, and I think I won every one of them. That's the attitude that lets me keep doing this. But anytime the Federal Society brings in somebody to the university, I've always been the go-to liberal, you know, and so I've done that many, many times. And I've always tried to do it in a way that was kind, you know, and respectful and dignified and yet powerful. I'm trying to teach my students, how do you persuade people and be a professional and be a good person, you know. You don't do it with name calling, you don't do it with insulting people. You do it with rigorous study and by really thinking about what's going to pull on people's heartstrings, you know. So I always have hope. I've debated Alan Gura on gun rights twice. I've debated Ilya Shapiro and all these other characters on immigration and other things. And I always have hope that if I can't change their minds, maybe at least I can show the audience, you know, the flaw in that kind of selfish, self-righteous feeling that they have, and show how, you know, my students at Duquesne, many of them very conservative, but they're also, for the most part, very caring people. And so when we talk about abortion, or when we talk about the future of the administrative state, and we talk about the needs of children and the needs of poor people, they're open to those arguments and they listen to them. And the feedback that I get from very conservative students is very positive. So I think I have reason to have hope, just from personal experience.
Parallel, you've been very patient, so.
Sir, I have a few questions. First is very short one. Is this the constitution of freedom of religion is limited to the mainland of USA or anywhere in the world for people or citizen of this country?
It would be anywhere under the control of the United States government. So, for example, a territory of the United States, the Commonwealth of Puerto Rico, the Constitution follows the flag, is the old phrase. Now, there's restrictions on military bases for obvious reasons, so you don't have full rights in places like that. But
otherwise, the citizens are allowed to do anything, whatever they want to do anywhere in the world.
no, I would say only if it's an area under the control of the US.
No, if it is not under the control of US, they can do whatever they want to.
Oh, yeah. There's, you know, if there's another government that makes it, I don't know, gay rights illegal or something like that, no.
Just to give you
The US, I mean, diplomatically, we would object, we would, you know, seek to protect American citizens, but they would not have a constitutional right, say in Iran or something like that.
just to give you an example, there is an invasion on India by Christian missionary for last 30 years, and 80% are from USA, and their budget is more than $100 billion. And there are organizations, I know more than 35 or more, called Vision India. They are recruiting people, training people, and sending there. And they are arming also some people, and they do all kind of things. So is that constitution allows them to do, like once Westinghouse gave a kind of a bribe in Egypt for selling the nuclear power plant, they were kind of penalized because it was a law that the US company doing the business even overseas cannot do the bribing. Now, in this case, freedom of religion here, is very good. But on other hand, they are freely, this is I call invasion because they are in thousands and thousands and thousands. And for last 30 years, every denomination of Christianity, Muslim have been there for 1,000 years, but Christianity has stepped up their stages to the degree that it can probably, you will hear in next other 30 years what is coming up back here from that part of the world. Thank you.
I think that's a question, you know, obviously I'm not an expert in that area. But you know, as a child, my church certainly supported missionary work. And I assume that that is now something that people look at and look at carefully. You know, that was the reason that the Baptist church split from in the northern and the southern parts. The Baptist church refused to let slaveholders be missionaries in Africa. You know, in the 1840s, they said you can't go, you know, to Africa anymore. If you're a slaveholder, that isn't going to work. And that's why the Southern Baptists, that was the immediate cause of why the Southern Baptists split from the Northern Baptists.
Thank you.
Yes,
You have time for another question?
yes.
Okay, my apologies because I came late.
Could you speak up real loud? Our microphone is great.
Okay,
Or you can repeat the question, Mike.
Okay, well, my name is Faye Bittmeyer, and at the point in which I came in, I thought I heard that the Bible is not law. I just wanted to clarify if I heard that correctly. If that is so, then I have something to say.
Did you hear that?
Yeah. It was law in Massachusetts Bay. The Bible was law in Massachusetts Bay Colony, and many of the court proceedings were actually conducted by not just the civil leaders, but also the religious leaders of the colony. And they would decide, for example, whether something was heresy. And then later they decided whether certain things were witchcraft, right? So you did not have a separation of church and state in Massachusetts. And that's what Roger Williams was rebelling against. Roger Williams thought that power comes from the people. It doesn't come from religious sovereignty. And, you know, the Bible wasn't law. The laws were to be made by the representatives of the people. And that was what distinguished Rhode Island from Massachusetts. And I think the US Constitution modeled itself after Roger Williams. And, you know, we have the words of Madison and Jefferson to support that in fact, they did believe in separation of church and state. And no lawyer, and I've been in court, you know, many hundreds of times, and no lawyer that I can remember has ever cited the Bible for a legal principle. You could, as an example, you know, the way Lincoln used it, as to what's right or wrong. For moral reasoning, yes. But as legal authority, no, it absolutely would not be legal authority. You cite case law, you cite statutes, you cite regulations.
Okay, well, I guess I would reasonably and respectfully disagree with the thought that the Bible is not law. It certainly is filled with God's. And I'm reading right now a wonderful book, The Light and the Glory. I wish that I had brought it with me, and I can only encourage as many people as possible to read the book, because it's filled with the understanding that God's hand was providential on the forming of America and very influential in the forming of the Constitution. And, as is always true, I mean, I've studied the Bible for decades, And, I can only say that, man in his thinking is finite and oftentimes flawed, whereas God is perfect. So anyway, I thank you for giving me the opportunity to speak.
Thank you.
Yes,
Um,
Karen.
yeah, my name is Karen, and
Karen.
I'm a good Karen. But my question has to do with the IRS. How the religion is viewed in terms of the taxes. I don't know if this may be off point totally, but
No, I'm not an expert. I'm not a tax lawyer. I have only probably the same understanding that you do. Donations to religion are tax deductible, the same as a donation to any charitable organization would be tax deductible, so long as it's not engaging in, political lobbying or endorsing candidates for office. And ministerial salaries are not taxed, as I understand, under the income tax. But I don't know to what extent other taxes, property taxes do not apply. And the Supreme Court ruled that was constitutional in Waltz versus Commissioner back in the 1950s. They said, yes, it's constitutional to treat churches as charitable organizations, to treat them as you would nonprofits who are exempt from property taxes. That doesn't violate the Establishment Clause. And I think that's correct. I think that's absolutely correct.
Mark, go ahead.
Well, just interesting predictive question here relating to the last question. In Bob Jones' university case back in the early 80s, the court said that because the government has an interest in combating racism, they could withdraw tax exemption from Bob Jones University, which had, amongst other things, policies against interracial dating and interracial marriage. Do you think Bob Jones could survive today's court?
We're going to find out. You know what the state of Maine did after they lost Carson versus Macon?
No,
after
no.
After the Supreme Court said that you've got to send that tuition assistance program to the parents of children who are going to go off to religious school as well. The state of Maine passed a law that said, okay, in order to qualify for the tuition assistance program, a school must not discriminate on the basis of sexual orientation, must not discriminate on the basis of gender identity, must not discriminate, and this one really shocked me, must not discriminate on the basis of disability. I am the parent, Nancy and I are parents of a man with special needs, and I've been running adaptive recreation programs for over 30 years. I coach basketball, and I am utterly without any athletic talent whatsoever, but I'm pretty good at working with people with disabilities, and I've loved that work so much. But as you all know, private schools and religious schools in general do not admit people with disabilities. So I was surprised to see that in the main thing. But just the part dealing with sexual orientation and gender identity, and both of the religious schools in the Carson versus Macon case do discriminate, do not admit children who identify as gay or lesbian or who are non-binary.
Teachers as well.
Yeah, and so now we're going to have to find out, is the decision in the Bob Jones case still good? And I guess we'll find out, because that's exactly what the state of Maine thought of. It's not, the Bob Jones school, everybody discriminated on the basis of race. And then the federal government passed an IRS rule that says, well, if you do that, you can't qualify for federal aid to education. And
Well, federal tax exemption.
yeah, okay, yeah. And now the state of Maine is doing the same thing. So we'll find out.
Interesting, interesting. Yes, please.
My name is Kathy, and I got a lot of questions for you, but I can't even begin to formulate them. One thing that concerns me is you mentioned, so long as we don't resort to violence, and we are, and the religious right is accepting violence. They are determining where violence is acceptable. And then that's it. I think that's a huge problem right now. The other thing is, as far as taxation, with the church's limitations and what they can do politically and whatnot, that's gone by the wayside with a lot of churches. They do what they want. They advocate for certain politicians in elections. They do all kinds of things. There's I'm sure you know about this conference tomorrow here in Pittsburgh, the Catholic Identity Conference. They're like a right-wing Catholic organization. And one thing that struck me when I was reading the article, the spokesman will urge resistance to Vatican endorsement of climate change hysteria and the worldwide lockdown, which I guess refers to COVID. To me, you're out of your ballpark, bud. No, but this is happening all over. The other thing that's happening, I think, is that people are religious groups are becoming very much money oriented. That you've got religious leaders who are making millions, if not billions of dollars. And people keep sending them money, which encourages them to be as radical really, because if they need to get attention, they need to, as they want to be. And what do you do about that?
But those are moral abuses more than abuses of the Constitution. Those are moral abuses.
How so? If you are telling people who to vote for, if you are telling people that all kinds of things that you're not supposed to be involved in, I thought.
There are some churches who do that. Not all churches do. Most churches understand that if you have a politician come and speak, you put your tax exempt status at risk. There are churches who still do it.
A lot of churches.
I think there's another part to it. They really put their own existence in danger. I mean, if you really care about becoming a better person, you don't want to sit there having political arguments with other people. If you want community and comfort and care, and all of that, the last thing you want is, to have to argue about Biden versus Trump or something like that. I think it's very short-term thinking on the part of the churches who are becoming very political like this. It may feel good, they may think it's great, but all the members who disagree with that particular position, what are they supposed to do? They're going to find something else. So I think it's self-limiting. I share your despair about it, but we've seen this throughout American history. It's not really that new. And you've had look at Elmer Gantry. You've had that kind of thing forever as well. And those people come into town and they go, or they're on television, but they don't really have they don't really have a congregation. They have a little studio. They're broadcasting by themselves somewhere. So yes, they make a lot of money. It's abusive. It's a shame, but I don't think that casts any shade on the millions and millions of ministers and priests and rabbis who are not particularly well paid and who, who labor for our communities and our congregations. It's such loving kindness. People that I admire so much. So, yeah, so there's always going to be a few that abuse. I don't let them color the whole group, and I think they've been around forever too. So.
Very frank.
My name's Mary Francis. One of the things that, that you referenced and so did Kathy is the Catholics for Change, or Catholics for Identity or whatever. I think you've got to realize that some people will call themselves, Catholics who do this, but they are not sanctioned or recognized officially by the church.
They are
And
not.
they are causing more problems for not just themselves, but they're causing more problems for the church itself. And that's very hard. Same thing happens with the Baptist or the atheist or whatever.
Yeah.
Yes.
Well, on January 6th,
Hello, everybody. We're back. Did you miss us?
I do not mean to imply that this group was sanctioned.
Okay.
No, that's right. And a lot of these groups are not sanctioned by their denomination. They get followers. That's the problem.
If I could just offer a thought. We'll talk about how religion is supposed to form the person, but not the government. If you look at St. Paul's letter to Philemon, okay, St. Paul's letter to Philemon talks about a slave who has escaped, came to work with Paul, and is being sent back to his master Philemon. Paul does not speak out against slavery. What Paul does there is he tries to convince Philemon that he should be treating Onesimus as an equal and not as a slave. The whole idea of changing one heart at a time, which I think is kind of the heart of what we're talking about here. Religion is aimed at changing hearts, not laws. Yes.
Will, I'm Mary Ann. My question is the tradition test. Whose traditions are we going by? Like, are we going by the native peoples that were here first? Obviously not. That was a sarcastic remark. But I mean, are we? So I'm curious. I understand the idea of tradition. It's concerning as a person who's third generation here, not from the 17 or 1800s. The idea of tradition is like, well, wait, like when my people first got here, or when they were treated badly, or after they got at least some rights, that tradition time might be okay for me. So anyway, just curious, how is this tradition, where is that coming from? What time frame?
I think it's, as you can tell from my speech, I think it's an absolutely terrible development. Do you know when our constitutional rights first emerged, when the Supreme Court first began recognizing them? You know, the country goes back, the Bill of Rights is written 1787, 1789, the Bill of Rights is written, becomes effective 1791. The first constitutional right to be enforced was freedom of expression. And that was in 1931. the flag case, the Stromberg case. The first time equal protection was enforced was 1938. First time freedom of religion was enforced was 1940. The first right to privacy case was 1942. Basically, since those rights have been recognized, they've had a realistic definition. The court really tried to figure out what's the meaning of this? What's the purpose of these constitutional rights? And they've applied that. And conservatives and liberals, yes, can apply those formulas in different ways. You know, intimate and personal rights, for example, for right to privacy. Liberals and conservatives will disagree about that, and I think that's perfectly legitimate. But it's another thing to throw the baby out with the bath and say, we're not even going to use those tests anymore. The other thing, Marianne, that the Supreme Court has been doing in recent years in order to ignore, you know, the dictates, the meaning of equal protection, the Supreme Court finally decided was that people who are similarly situated have to be treated alike. If people are equal, they have to be treated the same. That's what the court came to. And that's a really good standard. And again, liberals and conservatives might come to different conclusions, but nevertheless, it's a standard that is worth, you know, believing in and fighting for. A tradition test, in my opinion, is just worthless. It really is, because how do you know whether that tradition is worth keeping or not? It might be a terrible tradition. As Americans, with the exception of Native Americans, everybody else is an immigrant. I've done a lot of genealogy work in recent years, and I've traced my family back 11, 12 generations in America. You know what I found? In Pennsylvania, in Massachusetts, you know what I found? I found people who were slaveholders. The Cooper family in Pennsylvania were slaveholders. That's not exactly something to be proud of. I found in Massachusetts, I found somebody who came here and he was in 1631, he was hired and he was the engineer and he was building, he was laying out the towns in Massachusetts. Quite a guy, right? Quite a guy. And then he goes with Ellsworth, he founds Newport, not Newport, Hartford, Connecticut. His son and another relative that, you know, comes into play there, they go on massacres. They massacre Native Americans in their villages, women, children, men weren't even there. Hundreds in these villages, in these wars I never heard of. And I majored in history at Yale University. Okay, and I never heard of these wars that now I'm finding out my direct ancestors played a role in. So yes, I study genealogy. I am proud of them for what they, you know, their courage and for what they did. And I'm also ashamed of things they did as well. And I'm glad I lived long enough to discover the truth. My dad wasn't even sure what the names of his grandparents were. And he and I started on this project 20 years ago, and he passed away, and I kind of dropped it for a long time, but picked it up again. But you can see what I mean. I think it's important to know our history, but the reason it's important is not only to be proud of what they did, but to understand what they did that was terrible, and to rise above that and to understand why it was bad. The Supreme Court, this Supreme Court, Alito, Thomas, you know, that crowd, they don't seem to understand what tradition is. It is not always something to be proud of. It's something to be investigated and evaluated and weighed against, measured against the things that are really important. I think the Constitution is a moral document. Due process has moral content. Equal protection has moral content. And again, every 4 years, you and I decide what that content is.
Susan had her hand raised.
Good.
Susan had her hand raised.
Susan.
I did. I wasn't going to ask a question, just comment. I mean, if people want to really think about tradition, you know, for me as a Black American in my lifetime, there was tradition. that would go against everything, you know, including my marriage. My husband was here before, including my marriage. And it really scares me when I think of what tradition might mean, you know. I mean, I remember segregation well. I grew up in the South and I remember segregation well. So it's just, it's very frightening. I grew up with the notion that if it went to the Supreme Court, everything was going to be okay. That's what I grew up feeling. If it went to the court, we're good because they're going to, you know, I don't feel that anymore. That's for sure.
Susan, the Supreme Court, for most of its history, for 150 years, was thoroughly racist. The tide didn't turn until 1937. Franklin Delano Roosevelt didn't get any appointments to the court in his first term. That's why he was thinking of packing the court. They were going to expand it. And then, you know what they did? They improved the retirement package. Isn't that great?
Yeah, so like Westinghouse and every place else you work, right?
Yeah. And Roosevelt, over the rest of the years that he was president, I don't know, 9 years more, he got 8 appointments to the Supreme Court. And that's the Supreme Court that handed down, you know, he still had 5 justices on there in 1954 when they handed down Brown v. Board. And then, you know, Kennedy had a few appointments and Carter. And so and even some of the Republicans turned out to be fairly liberal. So you had a Supreme Court that did its job and it stood up for these principles. And now the Republicans have controlled the court since 1970, but the tide didn't turn until 2014, 2015, 2016, it began turning. And now you see all of those old tests, all of those old standards being replaced by tradition standards. And tradition, almost by definition, is conservatism. You know, that's the difference between conservatives and liberals, or people who are trying to keep things the way they've always been, and people who are looking to the future and hoping to improve things. And but they have a firm control, and a majority of them really like the tradition tests. And Susan, this is a terrible thing to say, but I wrote a book called, it's not really about liberal versus conservative, it's called The 5 Types of Legal Argument. It's used at a lot of law schools, but tradition arguments actually are valid. You know, in commercial law, we would call it commercial trade practice, trade usage. And there's a lot of validity to a tradition argument. It's just, it's not the only one. There's 5 valid forms of argument, and you have to take all of them into account. And sometimes one argument will be more persuasive than another, depending on the context.
Since we're about at 8:30, this will be the last question. Mark?
I can't resist asking another predictive question. This can't possibly happen until 2025. But if there's a Republican Congress and a Republican Congress and a Republican president in 2025, and I've been dying to ask this question to constitutional lawyers since Dobbs was decided, and they pass some sort of national abortion ban, do you believe that this court would possibly uphold the national abortion ban? Because if it does, and particularly in the case of Clarence Thomas, if they did uphold it, then I would believe that the court is completely in principle.
Well, yes, you're asking my personal opinion. Yes, I absolutely, I think they would find a way to uphold it. They didn't tell the truth this year in their major decisions. They were not accurate in describing what American traditions have been. So, for example, a national abortion ban, I have no doubt that they would, you know, decide that, oh yes, Congress does have the power to adopt a law like this under the Commerce Clause. You know, they would just turn around and on that. So yeah, I think they absolutely would.
Then I won't believe that Clarence Thomas is completely in principle.
Well, I've read a lot of Clarence Thomas opinions. Let me give you one to give you an idea of how principled he is. It was a cross-burning case, And I think I can safely say that all of us here hate cross burning. We hate it with a passion. Clarence Thomas is against it too. But when he wrote his opinion upholding the law, he said that it wasn't expression. It's not, so the First Amendment doesn't even apply, according to Clarence Thomas. Now you can uphold a law banning cross burning in situations where it's threatening people, where you burn a cross on a neighbor's lawn. I think, yes, that's an assault, that's a threat, and obviously we can prohibit it. If somebody burns a cross on their own property, far away from a highway or any other prying eyes for the benefit of their little Ku Klux Klan group, I think they've got a perfectly constitutional right to do that. It is expression, it is speech. Clarence Thomas took the position that no, they don't have the right to do that because it's not speech. He is an unprincipled judge. That's just the bottom line with him. It's too bad. It's a shame, but there it is.
All right. Well, thank you, Will, so much for your.
Thank you, everybody.
Your erudition.
Thank you.
We appreciate your time. Thank you.
Thank you.
Thank you.
Thank you.
Thank you all for coming out.
Thank you.
Thank you.
Thank you.